I was, of course, delighted to be invited to speak to you this morning as part of this extraordinary celebration of 100 years of the Red Cross in Australia. Congratulations to all of you. It's an event well worth celebrating, as the Red Cross is truly one of those iconic institutions that's universally respected and highly effective in protecting fundamental human rights and freedoms. Your values and your spirit of volunteerism have set a global benchmark to which each of us aspires. And in fact, coming in, I saw on the banner these wonderful words: relief in the time of crisis, care when it's most needed, and commitment when others turn away. Commitment when others turn away. That really is a very powerful message, and it's not always an easy role to play. Before I begin, I'm of course in this glorious environment here near the park and in Melbourne. May I acknowledge the traditional owners of the land on which we meet and respect their elders past and present. Well, I've been asked to speak this morning about some of the challenges and trends for human rights in the future, and I will certainly like to do so. And I've been very interested in the extent to which your workshops have engaged major, broad human rights issues, Indigenous issues, climate change, and of course I've been very pleased indeed to see how many young people are involved in this program and giving inspiring speeches and regenerating and providing the next generation for the Red Cross. I am going to concentrate, if I may, on the issue of asylum seekers, and I know you've had a most inspiring speech last night by Medeiros. I do, however, feel slightly awkward in talking about the law and human rights law, as I actually am going to, because I know that you understand very well the spirit and the principles of the law that I'm going to describe. You really get the fact that the human rights are about respect for human dignity. And to be perfectly honest, although I have, as an international lawyer, worked many years in this field, or certainly in the area of international law, one can get to a very high level of detail about the law, particularly international humanitarian law. For those of you working in that area, it's extremely complex law, but I've learned that you don't need to have that level of complex understanding to do the work that you're doing, nor indeed to do the work that we do at the Australian Human Rights Commission. It's the key point over and over again is the idea of respect and dignity for each of us. Well, I am going to talk about the challenges for human rights law, but before I do, I'm going to take up one of those issues that's always been rather curious and difficult for lawyers to understand, and that is, what is the relationship between international human rights law and international humanitarian law? They have different histories. I think we've been hearing about that. And it's been a key question for public international lawyers in the 20th century. How do they work together? Do they complement each other in the way that Robert was earlier describing? And the matter was resolved for us some years ago by the International Court of Justice in the Israeli security wall case. You'll recall there that Israel had built a security wall to defend itself, but it had done so on occupied Palestinian territory. And the question was whether or not Israel was legally responsible for human rights and IHL breaches in the Palestine-occupied territory. And the court looked at IHL law, the sophisticated, complex provisions of the Red Cross Geneva Conventions, and they also looked at the core principles of human rights law, the International Covenant on Civil and Political Rights, the Convention on the Rights of the Child, the Convention Against Torture being the major ones. And one of the rather special arguments that international lawyers love to make is that the specific is always trumping the general, the specific in this case being the principles of international humanitarian law. But the court reached a decision which is of enormous importance, and that was that the principles of the Red Cross Geneva Conventions and the protocols apply, and they apply equally and in parallel with and in a complementary way with the core principles of human rights law, the International Covenant on Civil and Political Rights and the rights of children and the rights of torture. And that was an important decision because it means that we were not, in a sense, competing with each other. What we're really saying is, what are the core principles that apply? And let's look at how they complement and work together. The other very important outcome of that decision was that a state is responsible for its acts and activities to the extent that they have effective control over them. Because one of the arguments was that Israel is not responsible for human rights breaches in the Palestinian occupied territory because that wasn't Israel, and it has no control over it. Well, as it was, of course, occupied, in effect, by Israel, the World Court had almost no tolerance for that argument and said, if you have effective control over the activities taking place in this territory, you are legally responsible for the human rights of the people within that area. Now, that's a decision a long way from us, and we may or may not have a view about it, but it's a vitally important issue for Australia in terms of the human rights behaviour in the offshore processing areas. So I think you can see where I'm going with this. The international legal principles are very, very clear indeed. States are responsible as a matter of law for their acts and activities to the extent that they have effective control over them. So it's with that in mind and those broad principles in mind that I wanted to raise essentially two questions that I think are really fundamental for human rights in the future. One is the domestic implementation of international human rights law as one of the greatest global challenges for the 21st century. We must give effect to this law on the ground, and it's one of the signal successes and assets of the Red Cross and Red Crescent that you understand far better than most how big the gap is between law and practice. And I'll come back to that in a moment. The other point I'd like to raise with you is, as I think one of the important challenges, is how we're going to improve international scrutiny of human rights and how we're going to improve enforcement of those human rights provisions. We've come a very long way in the 20th century, but we've got a long way to go in the 21st century. And these, I think, are the key challenges that in Australia we need to work on. But to come back to the first of the points that I wanted to raise, the domestic implementation of international treaties as being a very important global challenge, can I bring us all back to the G20 meetings that we've just been listening to and watching on our televisions, and some of you may be even taking part. Because I had the opportunity last week to attend a lecture given by the Chancellor Angela Merkel, giving the annual Lowy Lecture, and she very interestingly anchored her entire speech to the importance of the international rule of law, to democracy and human rights. And she came back again and again to those key principles in dealing with what for her is a vitally important question, as she put it, breaches of territorial sovereignty in Europe and, of course, mostly in the Ukraine. She sees this as a profound threat and one that she must stand up to. But having said this, and anchoring her speech in human rights law, within a few days, the chairman of Australia's Joint Parliamentary Committee on Legal and Constitutional Affairs said, Australians don't care about treaties or international law. And the raft of new legislation that's being introduced into Parliament at the moment, particularly with regard to migration and maritime powers, he said, was designed to stop the High Court interfering with government policy. The idea is to stop the High Court interfering with government policy. This is an astonishing statement, and what it does is raise what I believe is the exceptionalist approach of Australia to human rights law generally. But let's go right back in history and begin with some of the foundational ideas of the common law. As you know, next year we celebrate the 800th anniversary of the very reluctant signing of the Magna Carta by King John on the fields of Runnymede in 1215. And buried in the middle of this very complex document, and I do urge you to look at it, it tells you how much the volume of a glass of ale must be. It tells you the property rights of widows on the death of their husband. But then, in the middle of the document is the following clause: no free man may be taken or imprisoned or disseized of his liberties, or in any way ruined, save by the lawful judgment of his peers or by the law of the land. To no one will we sell or deny justice. These words ring through the centuries, and the right not to be detained arbitrarily is reflected in every common law and civil law system in the world. The idea that the executive government of a state may not detain a person without judicial process is a guarantee of ancient lineage that virtually every democratic legal system recognises as the sine qua non of their civilised nation. Yet today in Australia, we detain about 5,500 asylum seekers on the mainland, on Christmas Island, on Manus Island and Nauru, including 750 children on our calculations. We're the only country in the world that mandates the automatic and indefinite detention of children and their families on their arrival. We do so, as I say, indefinitely, and at the moment, on average, for over a year and 3 months, and in sadly many, many cases for several years. Since 2010, we've detained thousands and thousands of children in substandard camps, in remote and inaccessible places, with little or no education, without access to legal advice, without criminal charge, and without a trial before a court or tribunal. Asylum seekers have been held in legal black holes with no idea when they might be released into the community. Even when they are released on bridging visas, they have no work rights, and they're denied the right to make an application for a protection visa. But the opinion polls indicate that most Australians approve the policies of respective governments. And I should stress that the Australian Human Rights Commission is not a political body. Our views apply to the former government, the present government, and to governments stretching back to 2001, when these policies were first implemented. How is it that Australia's relatively mature and largely successful democracy has come to this? Why is it not possible to gain a writ of habeas corpus, to examine the legality of their detention? Why does Magna Carta not apply? Well, the reason lies in part because Australia is unique in its approach to human rights law. Now, some of you may be here in the audience and you'll remember the rather grand days when Australia, through the rather testy but brilliant Doc Evatt, was out there in the General Assembly of the United Nations, both engaged in negotiating that charter, but in negotiating with Eleanor Roosevelt the Universal Declaration of Human Rights in 1948. And you might remember that he was the president of the General Assembly of about 51 or 52 nations in 1948, at a time when Australia was just emerging as a new international state from the Second World War. And there he was as president of the General Assembly, and he, with others, but he managed to steer through the Universal Declaration of Human Rights without a single negative vote in 1948. And that Universal Declaration has underpinned so much of the law in international human rights law that's developed ever since. The International Covenant of Civil and Political Rights, Convention with regard to the children, torture, and the anti-discrimination conventions on race, disability, and sex. So Australia's been deeply involved in these negotiations. In fact, that phrase really applies to Australia in this context. We have punched above our weight. We've been out there negotiating, drafting, providing skills across the world to develop this body of human rights law, even up to the International Criminal Court, which was, of course, came into effect for Australia in 2005. So we've been a major player. But the very great sadness is that most of these treaties have not been given domestic implementation in Australian law. So we negotiate them, we sign them, and we ratify them. But we do not give them domestic implementation. Now, what do I mean by that? What I mean is that in the principle of parliamentary sovereignty, you can go off as a diplomat and negotiate a treaty. But when you come home with it, it still remains for Parliament to legislate that treaty into domestic law. That is part of parliamentary democracy. But the sadness has been that very little human rights treaties, or very few of them, other than in relation to discrimination on the grounds of sex, disability and race, have been implemented in domestic law. And curiously, the Australian Human Rights Commission's mandate is those international treaties. So when I speak to a minister or I intervene through our lawyers in the Federal Court or the High Court, the answer will be very typically, Gillian, that's very interesting that you've mentioned Article 9 of the International Covenant on Civil and Political Rights about arbitrary detention, but it's not part of Australian law. There are very few constitutional protections other than the right to vote, the right to freedom of religion, and the implied right to political communication. And indeed, I'm told on reliable authority that when Australians are asked, do we have a constitution, 90% of Australians say no. When asked if we have a Bill of Rights, 60% of Australians say yes. It seems that we learn about our constitution from the television. Not very long ago in Sydney, where I live, and where the Human Rights Commission is centred, a man was convicted on incontrovertible evidence of murdering his wife. And the police tell me that when he was arrested, he asked if he could take the Fifth Amendment. The sad truth is that in Australia, we have very few constitutional provisions, but we also know almost nothing about our constitution. So it's very hard to create a culture in which people say, these are rights that we must insist on. Australians are confused about the detention of asylum seekers. And that is part of the problem. But another part of the problem is that, unlike every common law country in the world, Australia has no Bill of Rights. And unlike New Zealand, the United Kingdom, Europe, Canada, and the United States, and many other civil and other countries, they have bills of rights, and they view all of their laws through the prism of a human rights charter. We do not do that. We don't speak that language. But our cousins in New Zealand do. If you're speaking to an English lawyer now, they will always, if it's even a banal issue of rights to property, they will always say, but what does that mean for the purposes of the Human Rights Act? But we don't have it. Additionally, we're in the one region in the world where there is no regional human rights treaty. There's no regional court to develop jurisprudence, unlike Europe, Latin America, Africa, and now in the Arab Middle Eastern regions. So that we have trouble in our own region in understanding what the rule of law is in relation to human rights, because most states within the Asian region have not ratified the relevant treaties, and we have no common jurisprudence in relation to human rights. But some of you may be saying, well, that's a rather gloomy picture to portray. What's the reality? We know that in Australia we live in a world of very high respect for human rights. It's limited, it's fragile, but it's very much a part of our culture. And we would talk about it as the culture of a fair go. If you asked a woman in the Burke Street Mall, has she got a right to freedom of speech? She'll tell you, of course she does. But if you asked her what the legal basis for that right to freedom of speech is, she won't have the slightest idea. The truth is, a right to freedom of speech exists in Australia because our courts say there is a right to freedom of speech as part of the principles of legality or principles of interpretation. But we have no legislative or constitutional provisions in our law that protect these rights. And we've recently heard the High Court in the Bikie cases saying there is no right to freedom of association either. So we have a culture that respects human rights, but we don't actually have legal provisions that do so. And we have all sorts of principles of statutory interpretation. We have a very recent and important development in the Commonwealth Joint Parliamentary Committee on Scrutiny. You may hear much more about this over the coming years, and it's probably one of the most important developments in human rights for decades. And that is, this committee will look at every piece of legislation to see the extent to which it engages human rights. And of course, there's the work of the Australian Human Rights Commission. We have quite broad powers as president. I can call inquiries, and I'll mention that in a minute. We have an advocacy role, we have a monitoring role in relation to detention centres and prisons, and we have a complaints process, and we receive about 21,000 complaints a year. Unlike the Red Cross, we are out there advocating. We work in the public arena. My job isn't to be liked by everybody, as Robert has pointed out. Your job in Red Cross, though, has been a very different one. You are working behind the scenes, you're working to change policy, you do so in a much less, if I may say, confrontational way than the kind of position that I have to find myself in all too frequently. But we have to speak up for those rights, and a very interesting phenomenon is that the Australian Human Rights Commission is appointed by the government, by the Governor-General. We are paid for by the taxpayer, but we are completely independent statutory bodies with pretty well guaranteed positions. So a mature democracy can allow my position to exist. It is a very curious one. And I've recently been invited to China to talk about whether China would establish a national human rights body with somebody like me in that position. They're not quite ready for it yet, but they're moving, they're moving in that direction. And I think they probably will eventually get one. But I think you can see that it is a sign of how mature Australia is, that the government is prepared to provide us with at least an appropriate budget, 140 employees, and to allow us to do the work we do, to be outspoken, even though on occasions governments are unhappy with that. Well, that's how it works in Australia. But then there's a very serious and fatal flaw with the system, and that is that the common law principle of legality will always be trumped by the clear words of the statute. And that, again, reflects the principle of parliamentary sovereignty. The courts are bound to apply the unambiguous words of legislation that have been agreed to by an elected parliament. And there are some very, very important illustrations of how this works. And one you might remember, the Al-Kateb case in 2004, 10 years ago. This is probably a low point for Australian human rights law. It was a case in which Al-Kateb was a stateless man, and because he was stateless and applying for refugee status, he couldn't be sent anywhere else because no other country would take him. And he was then held by the minister on the basis of administrative executive discretion for 4.5 years in Villawood and elsewhere, in closed mandatory detention. He was adjudged not to be a refugee, but Australia could do nothing with him. So the minister said, well, under the Migration Act, I will detain him for as long as I choose. He can't go to the court and complain, and he had tried, but finally some lawyers brought the case to the High Court of Australia. And the High Court of Australia read the Migration Act and said the language of the Migration Act is entirely clear. The minister has two options. He can either deport or he can detain for the purposes of determining his refugee status or to give him a visa to remain in Australia. And he can do so as long as he chooses to do so. So in a 4 majority decision, the High Court of Australia said the minister could keep Al-Kateb for as long as he liked in closed mandatory detention. Now, I should say, because I know that you have the wonderful Michael Kirby here later this afternoon. Michael Kirby was on the High Court at that time, but you won't be at all surprised to know that he was in the minority of that judgment. And he said, and again bravely said, the principle of legality and the principle of the liberty of the subject is the primary consideration. There may be some legislation here that allows the minister to do what he's doing, but that is to breach that principle. The other judges in the minority were a little more conservative, as High Court judges tend to be, and they said, we'll read the statute down. It doesn't make sense the way it reads at the moment. We'll read it down. But that was 10 years ago, and what it did, very sadly, was to give the government executive power to hold for administrative purposes any detainee for as long as they chose, without any ability effectively to go to the courts and have this dealt with. Until about 3 or 4 weeks ago in a case that's rather boringly described as Plaintiff S4. And Plaintiff S4 was a not dissimilar case. He was a man who'd been held in mandatory detention for 2.5 years. He was also stateless and couldn't be sent anywhere else. But in this case, Plaintiff S4 was adjudged to be a refugee, and he was a man of impeccable character. There was no slight or no allegations that he didn't have appropriate character qualities to be an Australian or to have an Australian visa. But he too had been held for a very considerable period of time on the basis of the old Al-Kateb decision. But this time, the High Court came to a completely different view. view. It was a unanimous judgment of the High Court. You don't come across this very often, but a unanimous view of the court. And the court said, certainly the minister has a power to detain asylum seekers, but this is not at the unconstrained discretion of the minister. An alien is not an outlaw, and they can be detained only strictly in accordance with the law. Certainly the minister can deport, but you can't deport here because he's stateless. And certainly the minister can take some time to determine whether or not he can apply for a visa. But the decision must be made one way or the other by the minister as soon as is practicable. And those magical words may unlock the door for many of these people, because the decision must be made. Now, I'd suggest that 2.5 years in the case of S4 was far too long. The practice in much of Europe, comparable legal systems, might be 72 hours in one jurisdiction, it might be a few weeks in another, but never, on average, for children, 1 year and 3 months as it currently stands. And it's been much, much longer for many others, especially those adjudged to have a security assessment that's negative by ASIO. But also, the High Court, for the first time and unanimously, said very sternly, if the minister does not make a decision one way or the other to deport or to grant a visa, the court will use its constitutional writs, the writ of mandamus, to require him to comply. I have never seen that in a judgment on this matter. So how this is resolved in the future, I don't know, but it gives you some idea of exactly what has been happening in Australia and on the basis for the Australian people as a whole. The second element that I wanted to raise with you briefly is, and I think it's a very important challenge for the future because it tends to undermine the viability of international human rights law, is the challenge to improve scrutiny for human rights standards and to ensure enforcement of those international standards. I think you all know it's a matter of huge frustration. And when I used to be an academic, I would always get young students asking me that question in good faith. You've taught us all of this, you've told us about these principles, and we've looked at the law and the cases, but they're ignored. Of what use is it if it's not going to be complied with? And we all know that one of the critical characteristics of any good legal system is that it will be enforced. Not necessarily by police forces or armed forces, but it's enforced partly because of culture, and that is relevant in Australia, but it must be respected, and we must make some changes. We've been under very considerable international scrutiny for our asylum seeker policy. You might remember or know that last week the United Nations Torture Committee has been looking at Australia's practices with regard to asylum seekers and grilled us, I might add, in Geneva for more than 3 hours on trying to understand why Australia, as a good human rights citizen, is now embarking on an offshore processing and mandatory detention policy. That committee will report shortly. We have 2 legal decisions of the Human Rights Committee in the United Nations to say that not only is our asylum seeker detention policy contrary to the arbitrary detention provisions of the International Covenant on Civil and Political Rights, and of course in breach of that core provision in the Magna Carta, but for the first time some months ago, that Australia is in breach of the obligation not to impose cruel and inhuman treatments under the Torture Convention. It is really quite shameful that for the first time Australia has now been called out under the terms of the Torture Convention. That has never happened before. Those findings by the UN Human Rights Committee have been completely ignored by the Australian government and are very little discussed in the media. The High Commissioner for Refugees frequently expresses his concern about our policies and reminds Australia of its international obligations and the Refugee Convention. The UN Working Group on Arbitrary Detention has been denied access to Nauru and Papua New Guinea. The Human Rights Council, to which we are, or in relation to which we are now seeking a seat. We want to be elected to a seat to the Human Rights Council. In my view, we deserve a seat, we should get a seat. I think we will get a seat, but it is embarrassing to be President of the Security Council, as we are at the moment, very effectively, if I may say so. But we're President of the Security Council, we're seeking a seat on the Human Rights Council, and yet we're carrying out policies that are called into question by the major United Nations monitoring bodies. The High Commissioner for Human Rights in the United Nations, Navi Pillay, before she retired, and the new President, a new Human Rights Commissioner, have reported to the Human Rights Council their profound concerns about Australia's asylum seeker policies. But we also have the monitoring roles of the Red Cross, which are absolutely vital, and of course by other groups of Amnesty, Human Rights Watch, and the Australian Human Rights Commission. We have then a strong concern with the international community about our policy, but we have very few mechanisms for practical enforcement. And I think if the young ones are going to think about where we're going to go in the future, we have to work harder to find effective mechanisms to give effect to the structures that we've built. So since the days of Doc Evatt, we have been able to build the laws and the principles, some of them very complicated, perhaps more than is really necessary. But we haven't yet mastered how we're going to ensure that governments are accountable for their human rights breaches. And that brings me finally to just a very brief word about our inquiry. The Australian Human Rights Commission has been monitoring the detention of children and their families for at least the last 20 years. And we've reported in two major reports, one called The Last Resort 10 years ago, when the then government incarcerated children in this way. And I'm very pleased to say that shortly after that report was issued, the Howard government did manage to release all but a handful of those children. And that, while I, of course, don't claim any credit for that change, we do believe that the Human Rights Commission and our detention centre visits and inquiries can have an impact. Similarly, my predecessor, the Honourable Catherine Branson, also in a report dealing with asylum seeker children who were being assessed for their age by reference to wrist x-rays, for which there was no medical or scientific evidence whatsoever. There, again, she worked wonderfully with the government, and the government stopped using that process and adopted more scientifically appropriate tests. Now, they were two successes, and in part, of course, encouraged me to hold and call an inquiry into the current detention of children. We have completed that inquiry, and the report is now with the Attorney General, who is required under the law to table that report in Parliament within the next few sitting days. Whether that's before Christmas or after, I don't know, but in any event, I very much look forward to that report being in the public arena. One of the things that I wanted to mention about it is that this report is based on evidence that is both qualitative and quantitative. We interviewed about 1,300 imprisoned, detained asylum seekers, children when we could, and families where it was more appropriate. We held 5 public hearings in which, on the record, the former minister, the Honourable Chris Bowen, and the current minister, the Honourable Scott Morrison, agreed that holding children in detention is not a deterrent against people smuggling. That is very powerful evidence, because we simply cannot understand why the children and their families should be detained for such long periods of time in a context in which it has no deterrent effect. I cannot tell you about our findings and so on, but because that does depend on the report being tabled. But I can tell you that there is evidence on the record that one of the great impacts of detention on children, particularly for delayed periods of time, are very significant increases in mental illness and in their physical development over the years. The longer they're held, the sicker they get. And when I because I wanted clear medical evidence for our inquiries, we went to every detention centre holding children in Australia. I've been to Christmas Island 3 times, and I've taken psychiatrists, psychiatrists, paediatricians, people with a lot of experience in this area, and one of the phrases that rings through my mind more than anything else was the view of a senior paediatrician that every child, or virtually every child on Christmas Island, was sick. So I will say no more about that, except to leave you with one story, if I may, and that is I'd been on Christmas Island for a while. I was really charmed by the numbers of children. If I sat down for a moment to write my notes up, the children would gather around because I had paper, I had pens, I had yellow fluoride markers, I had stickers with colours, and you'd get one child and another child, and you'd have a table all with these coloured materials to work with, because they'd had nothing, no materials at all in the dirt and the dust and the phosphate grime and grit of Christmas Island with the chickens and the general despairing atmosphere. These children with their bright, bright faces, absolutely fascinated by the idea of yellow stickers. And I remember saying to them as they, because I had so few materials, share. And many didn't have English, and they were sharing the word share around the table as they passed the pen around. Share was a new English word. But can I finish with the story of an 11-year-old girl that really did damage my professional cool in the situation? She was telling me with great composure, she had left Somalia, where the local fighters, fundamentalist groups, had tried to take her away from her family to become a slave of one kind or another to a local leader, and her father refused to let her go, and he was then put in a Hessian sack and left on the road to be run over and killed. Her family, her brothers and sisters were killed, her mother was dead, but an aunt in Kenya smuggled her out to Malaysia and ultimately to Indonesia, into the hands of people smugglers, and she came to Australia without a visa, 11 years old. She told this story calmly about what it was like to be on the boats, to be surrounded by the fear of sharks and waves. She got to Australia. She was imprisoned effectively on Christmas Island and had been there for a year. She was calm and composed as she told me this horrible story. But then she said, I've been on Christmas Island for a year and I've had no school, no education at all. And it was then that she burst into tears. And I have to say I came very close to it myself, because she knew that when you strip away that capacity for education from a child, you've really destroyed their future. And she knew that instinctively, that was, she could put up with the conditions, she could manage this horrendous journey. She wasn't asking for clothes or better food or anything else. She was asking for education. And I think that is something that Australians know the importance of more than anything else, because it's been a key to the secret of our success, I believe, as a multicultural society. Well, in conclusion, and I have perhaps gone a little over my time, and I apologise for that, international human rights law and human rights law, the Red Cross and the Australian Human Rights Commission work together to build on a culture of human rights in Australia. Basic dignity and respect for all is the key to all of our work. I really congratulate all of you for your work. You're absolutely fundamental to all that I've been talking about today, and I hope that you can carry that compassionate message forward, that the laws that we've worked so hard to create now need to be implemented in effect in Australia. Thank you all very much.